All right, so not going ahead as planned tomorrow. And let's look at another legal matter affecting the former president. The Constitutional Court has asked parties involved in Jacob Zuma's rescission application to make submissions about a UN covenant on civil and political rights. Zuma launched an application for the court to rescind, or basically change, its decision after it sentenced him to 15 months in prison for contempt of court. The court is still applying its mind, and it's now asking for legal opinions about that UN covenant that was not brought up during the arguments for or against the rescission. The court says that international treaties, the Constitution rather, says that international treaties should be considered, and the highest court wants to know if it is obliged to consider that covenant which talks about the rights of all people to due process and a fair trial. To discuss, we're joined by Tseli Phooko from the Faculty of Law at the University of Johannesburg. Thank you for being with us, Mr. Phooko. The Constitution itself says if there's any open-ended matter, these foreign treaties, these laws that we have subjected ourselves to have to be considered. So tell us firstly about the UN Covenant on Civil Rights and Political Rights.
Good afternoon, Francis, as well as good afternoon to the viewers. Well, basically, once a country ratifies a particular convention, such as the International Covenant on Civil and Political Rights in this instance, and ratifies it, it basically entails that South Africa now is obliged to give effect to the provisions of that particular treaty when applying its domestic laws.
And Professor, what does the covenant say? How could it possibly affect this case?
Well, if we look at Section 9 particularly of the Covenant, International Covenant on Civil and Political Rights, is a replica of our Section 35 of the Constitution, in that it provides various rights for a particular person, accused person, and a detained person, or someone who has been deprived of his liberty. Then Section 14.5 of the Covenant basically now says, where everyone has been sentenced by a court and is serving a sentence of incarceration, that person is entitled to have his or her sentence being reviewed by a court. In this case, this is what is happening before the Constitutional Court. So basically, the covenant sort of guarantees all those rights have been provided for in the Constitution. And the fact that you have been sentenced, it doesn't mean that it's the end of the matter. You still have remedies to apply to a superior court to review the otherwise, correctness of your sentence.
And this is important because Zuma's advocate had argued that what the Constitutional Court did was effectively detain Zuma without a trial. However, the court said it had considered the evidence, and also, as it would have in a trial situation, given him ample opportunity to give his side of the story. Do you think this changes those two sides of the coin?
Well, basically, it still says it doesn't change much. The argument's still the same. I think even if they are advancing similar arguments under international law, they would still argue the same grounds, that we understand that, this was a civil court contempt. In other words, the previous decisions provides that you can be summarily incarcerated if you have committed a civil court contempt. But now the question that the courts have to really battle with here is that, can we really say under a new constitutional order which guarantees everyone the fundamental rights to freedom and dignity, can one be subjected to incarcerated without being afforded a particular right to be heard?
Yeah.
And international law is very clear on this one. It provides that, before you can decide the fate of the accused person, no matter how bad that person is, at the very least, you need to afford them the right to state their case.
But didn't the court do that, I think, as the Zondo Commission lawyers argued?
Well, the court did that. Everyone can attest to that because he was given an opportunity. Please do come forward and state your case. Unfortunately, he did not present himself. Yeah. But that is not the end of the matter. Even if he did not come, he still have a right to launch an appeal or consider have his sentence being reviewed.
Yeah. Do you think the Constitutional Court here is considering all its bases, just making sure that it doesn't leave out any relevant argument, any piece of law that might pertain to the case? Is that what it's doing?
Well, Francis, I think that's basically what the court is doing now. You know, this is a very interesting judgment, a case, and it has attracted a lot of international media, and people are very keen to read. I mean, we are all looking forward to read the actual judgment. So the court is, by and large, ensuring that there is no piece of law that is left unchecked in arriving at the correct conclusion.
All right, let's see what the lawyers on both sides argue about this UN convention, and let's see what the Constitutional Court decides. Thank you very much. That was Tseli Phooko from the Faculty of Law at the University of Johannesburg. Thanks.